Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking this morning at a book from Jordan Publishing which is in their new employment series. It's called Costs in Employment Tribunals. It's this little book here, 250 pages, not a heavy book in the sense of weight, but a lot of detail. Chapter headings very much in the Jordan tradition. Paragraph numbering at the sides, and lots of case laws, which are case law statements which are put in boxes. You've got a lot of very interesting areas, things like vexatious litigation, various points right at the back, including a useful index. And you've also got things like costs in other courts, which I found helpful, because I think this book applies not just to tribunals in terms of the general approach, but is helpful, say, for small claim cases where you may be looking for unreasonable cost orders. There's a Flickr review written by my wife Elizabeth and myself, which is on the internet and the web generally. And as I say, this is a book which I think has a much wider application than just for the tribunals themselves. We've given it the title, Obtaining Costs for Your Clients in Employment Tribunals. Not an easy task for advocates who need help with their case for costs, and that's really where this book comes in. I haven't seen it really on the bench much so far, but I imagine the judges do look at it. What we say is this: if you are a practitioner advising or representing clients in employment tribunals as an advocate, this book will offer you enhanced insights over costs issues and the pointers we need to consider when making specific costs applications, bearing in mind their discretionary nature. And as I said, it has a wider applicability in my view. I'll explain why. It's recently published as part of the Jordan's Employment Law series, and it's a project which in our view is unique, examining over 100 hitherto unreported cases, which together build up a picture of when costs are awarded and when they are not. The author team, and there are three of them, Daniel Barnett, Kate Palka and Benjamin Hay, you can see their name there, a bit of blurb about them on the back. They're basically two barristers and a solicitor. They've set out to distill the way the courts, the actual courts, look at cost rules, and in this case it's tribunals, and how they're implemented in up and down the country. And to do this, they've elicited the help of numerous barristers and solicitors and what they call a small handful of tribunal judges. Very helpful here, because it gives us our thinking, from various locations, and those people have provided copies of the written reasons for tribunal decisions, as well as in some cases transcripts. These are summarised and commented upon in the book, and gleaned from real cases. The results are certainly revealing and definitely instructive, and I think extremely helpful when you're thinking of that question of costs, notwithstanding what's going to happen to the case. The authors warn, of course, that even though in general employment tribunals do not award costs, there are circumstances in which they may or must do so. But if they do, the rules differ, of course, from those that apply in the courts. And they do, of course, mention costs in other courts at the back. But you don't need to carry the green book, the white book, or any other book around with you if you've got something like this, because this will give you what you need in a relatively short number of pages. So in employment tribunals, the authors add, an award of costs is related to the conduct of the parties rather than to whether they win or lose, which is an interesting move away from the old strictness of what effectively was the common law rule, in that costs follow the case. Can I just say that costs orders are the exception rather than the rule in employment tribunals, and it stems from their specific nature and purpose. Employment tribunals were and are, as Lord Justice Stephen Sedley has stated, designed to be accessible to people without the need of lawyers. Therefore, losing does not ordinarily mean paying the other side's costs. I will tell you, I don't necessarily agree with that, because some employment tribunals I've found to be far more formal than some of the county courts that I've been in, but there again, depends on what your practice is like. Let me conclude by saying that the expected reference tools are all in place here. You've got tables of contents and so forth. You've got a useful appendix on employment tribunals, constitution and rules of procedure regulations. And so for the employment lawyer and the tribunal judge, or even the human resources consultant, this book should be required reading to help you advocate your best case for costs. I think it helps, and I'm delighted to have it in my library. So thank you to Jordan and the authors. Bye-bye.